Today is the 27th anniversary of the Olmstead Supreme Court decision. This is a day that often people with disabilities in the disability community are celebrating because the Supreme Court decision from 1999 held that people with disabilities have a right to community living and community integration. However, unfortunately, this Olmstead anniversary is shadowed in a lot of fear. And that is because last week, on June 18th, an opinion from the Department of Justice's Office of Legal Counsel, or OLC, addressed to the White House Counsel's Office, concluded that neither the Rehabilitation Act nor the Americans with Disabilities Act require states to provide care to people with disabilities in the most integrated setting possible, effectively dismantling the integration mandate with this opinion. The OLC's new opinion does not change the law, does not change legal precedent. So I want to be really clear there. And I actually am a lawyer for people not following along. But it could fundamentally change the way that both the Department of Justice and the Department of Health and Human Services, which is the department that oversees Medicaid, enforces allegations of discrimination and could have a chilling impact on access to home and community-based services. The three core conclusions were that Olmstead didn't actually hold what people think, that the Supreme Court's holding was actually very narrow, which is not what has been held in other cases around Olmstead for 27 years. It also held that Congress never imposed the integration mandate and that HHS and Department of Justice regulations imposed the integration mandate exceeds statutory authority. So that's what this memo is saying. Ultimately, though, this opinion provides legal cover for states to institutionalize people with disabilities. That's why there's so much fear. It could be for any reason from resource constraints, safety concerns, capacity limits, without running afoul of disability law. It also signals that the Department of Justice's Civil Rights Division should stop enforcing Olmstead-based consent decrees and deinstitutionalization agreements. Really, really troubling there. This is a direct attack on decades of Olmstead enforcement and community integration as a civil right. It has major implications for Medicaid home and community-based services. Let's not forget that because of the nearly $1 trillion that was cut from federal Medicaid spending by the majority of Congress and signed by President Trump last July, states must now make deep cuts to a whole range of services previously funded by Medicaid. And this memo, the most chilling part of it is that it essentially gives states permission to cut these community-based supports and instead rely on institutionalization, even if it's not fiscally responsible, what most people want.